Hi, welcome. Francesca Albanese. Francesca Albanese was appointed UN Special Rapporteur in May 2022 and is also an international lawyer, human rights expert, and affiliated scholar to Georgetown University. We are lucky to have you, Francesca, and we are sorry that you are not here in person. We are in Bergen, a rainy city. Where are you connecting from?
I just arrived in Paris.
Okay, great. I would like to ask you first a bit more about your role as UN Special Rapporteur. What is your role? And also, since 2008, Israel has denied access to all UN Special Rapporteurs for the Occupied Palestinian Territory. So how is it also Israel lack of cooperation and denial of entry has impacted your investigation?
So first of all, thank you very much for inviting me. It's a pleasure, and not. I mean, it would have been better, of course, to be with you in person. It will have to be for another time, but still very glad to be part of this panel. And look, special rapporteurs are independent experts appointed by the Human Rights Council by virtue of their specific competence, either on a given topic like right to food, right to water, right to health, or on a given area of the world. There are 14 mandates which focus on specific geographic areas. Like this is my case. My mandate is to look at violations of international law, both human rights and humanitarian law, committed in the occupied Palestinian territory. So traditionally, the mandate has been focused on Israeli violations because this is, I mean, Israel was the main and only duty bearer when the mandate was created over 30 years ago. As a mandate holder, I made clear that I would look at violations committed by anyone, including the Palestinian Authority and Hamas as the de facto authority in Gaza. And this was not in an attempt to address the criticism of partiality that Israel, supported by the United States, have always moved against this mandate. This is just to start commenting on the cooperation that I enjoy from the Israeli authorities. But it is to say that this has not sufficed to placate the animosity against this mandate. So I should undertake 2 visits per year in the occupied Palestinian territory, upon which I, based on observations and examination of the reality on the ground and existing documentation, because it's an area where violations are fully documented by Palestinian, Israeli, and international organizations. And then I should submit my report, once to the Human Rights Council and one to the General Assembly. Israel, as you were rightly pointing out, has not allowed special rapporteurs on the occupied Palestinian territory to enter the territory since 2008. Richard Falk, my predecessor's predecessor, was even arrested as he tried, and he had coordinated with the Israeli authorities to enter the occupied Palestinian territory. So this was a clear message that this mandate was not welcome anymore. As of now, well, first of all, I've tried to go over and over, and I'm trying to go next week as well. So it's not that I'm deterred from the let's say the hostility to my mandate, because I still have a strong sense of responsibility toward the people who suffer these violations through and through. But the thing is that it's very complicated without going, although I've lived in the occupied Palestinian territory, so I have a quite concrete sense of the reality. At the same time, it's not the same. It doesn't compensate for for what an in-country visit can give you. In lacking this, for the past almost 2 years now, I've had hundreds and hundreds of meetings, virtual meetings, including virtual tours given to me by both Palestinian and Israeli human rights organizations, and hundreds of meetings with victims and survivors of violence, including for the last report, which was presented 10 days ago, called 2 weeks ago, Anatomy of a Genocide. Last comment on cooperation from Israeli authorities is none. There is zero cooperation, and there is a lot of hostility against the mandate, which of course I regret. But I also understand. I mean, Israel has set up a system, an apartheid regime, which wants to preserve itself. So the last thing they want to cooperate with is anyone who sees the reality for what it is in its complexity, but also in its simplicity, and tells it to the world.
Of course, and connected to that, precisely to the apartheid system that you have denounced, and also you have been very vocal, and you have highlighted the need throughout all of your mandate to address the settler colonial nature of Israel's occupation in Palestine. In your latest report that you've mentioned, Anatomy of a Genocide, you describe the situation in Gaza as the escalatory stage of a long-standing settler colonial process of erasure. On other occasions, you have denounced the apartheid system as the spine of Israel's settler colonialism. So I would like to take some time to understand such long-standing settler colonial process and its implication for the rights of self-determination of Palestinians, which you define as the platform right for many other rights. So what is Israel's settler colonialism? Its main structural components and manifestations across Palestine throughout the decades of occupation. And also, how has this impacted the right of self-determination of Palestinians?
I think it's very important to not to be afraid to spell out the very nature of Israel's endeavor in the occupied Palestinian territory, and also to link it to the very nature of Israel's interaction with the Palestinians as a state and as a state project. And in my first report to the General Assembly, I focused on the right of self-determination. As you rightly say, yes, the right of all rights, because it's the collective right par excellence, is the right that belongs to a people to exist as a people, free to exist demographically, economically, politically, and culturally. This is the simplest way to describe the right of self-determination, which otherwise sounds so theoretical for us who enjoy the right of self-determination, right? But if we ask people who do not enjoy the right of self-determination, who are under oppression, subjugation, and denial of a national identity, they will know what it is. So this right has been denied to the Palestinians since the very beginning of the existence of the State of Israel. And with it, I don't challenge the existence of the right of Israel at all. I'm not among those who challenge the state per se, although in international law, there is not such a thing as the right of a state to exist. This is something that is repeated over and over, but doesn't exist in international law. What exists is the principle of sovereignty, which states are very jealous of and which I respect, but there is the right of the people to self-determination. So there is the right of the people to exist as a people. And as of 1947, actually, since the very beginning, we tend to think of the creation of the State of Israel as something that humanity all of a sudden gave to the Jewish people to compensate them from the indelible wounds of the Holocaust that are indelible. it's not, it's much more complex than that. But however, there was already, because the Jews in Europe had been persecuted for centuries, and many of them didn't feel welcome in Europe. There was the birth of the Zionism as a political ideology, thinking that they should have a state on their own, the Jewish state. And there were various options: Argentina, Uganda, Utah considered at the time. Palestine was the one who made more sense because the Jewish people had ties, historical ties with Palestine. And this was at the time of the Ottoman Empire. This is when it started. And then it continued. And so when the Holocaust occurred, there was already this project to create a Jewish state in Palestine. The point is that while no one disputes the ties and the attachment of the Jewish people to that land, nothing gives the title to the Jewish people to displace the other inhabitants of that land. This is true today in 2004 and was the same 100 years ago. And it has been condoned over and over. And this is why, in my first report, I said, still, as of 1967, in what remains of Palestine, in what didn't become the state of Israel, Israel has built colonies after colony, further displaced Palestinians, taking land and homes, dunam after dunam, really inch after inch, and it continues. Even now, at the time of atrocities being committed against the Palestinians in Gaza, the discourse is, we are reconquering Gaza. They're already making plans to rebuild settlements in the Gaza Strip. So this is why I say, ultimately, it boils down to the right of self-determination of the Palestinian people, which entitle them to exist in the land and also to resist the oppression. I know that Western audiences don't like this argument, but again, international law is universal, and this is its beauty and its force. And the other thing is that Israel behaves as a settler colonial regime. And settler colonialism is, in its simplest form, the taking of the land and its resources from the native people. There might be more than one native people, but here we are talking of the Palestinians, and also transfer of civilians that are not native from the land. This is what settler colonialism is about, and this is what Israel is doing to what remains of historic Palestine.
Thank you so much for this clarification. In one of your other reports, you have described the arbitrary deprivation of liberty in the occupied territory as one method, as a tool of settler colonialism, beyond and behind bars. Could you please explain what's happening in terms of confinement architecture in Palestine and administrative detention and mass incarceration procedures, and how are they an instrument of settler colonialism?
Let me say first something, because I'm not sure if the audience includes primarily law students and legal scholars, but if this is the case, I would like, especially to the students, to address a message, because we, in the pursuit of rigor, as in any discipline, we tend to stay within the confines of what is given to us. So just the black letter doctrine interpretation of the law, you interpret the law according to the norms, the treaties. But we live in an ecosystem made of many interactions, and I've learned so much over the past years from other disciplines, including anthropology and international relations. And without this, I wouldn't have made the connection between what is happening now and the past, because as I was studying this past 6 months, what is genocide, I realized that what is happening now was, as I wrote in the report, a tragedy foretold, because settler colonialism, as Raphael Lemkin, the legal scholar, the Jewish legal scholar who gave the world the term, who coined the term genocide, he had settler colonialism in mind, because settler colonialism as wanting to annihilate the natives is genocidal in itself. Therefore, you realize that there are various steps, various methods of controlling and segregating and the population so that it doesn't constitute a nuisance to the settler group and or the dominant group, let's put it this way, if it's more suitable. However, what has happened over time is that the Palestinians had to be confined through and through, and because the one this has happened structurally because of the taking of the land to build colonies, to build military bases that secure the colonies, and so the Palestinians have been pushed out into reserves. People talk of Bantustans, but 60% of the of the West Bank is fully controlled by Israel. So the Palestinians exist in portions of land that has been left to them as autonomous zones, but to an extent. Therefore, I said, first of all, arbitrary deprivation of liberty has become a method of control. And if you see the legal grounds for which Palestinians get arrested and detained, also charged of terrorism, I mean, it's an aberration, because in most cases, and this without condoning crimes that Palestinians might commit against Israelis, but in general, if you look as just a naive lawyer at the legal grounds that lead Palestinians to be arrested, it's absolutely astonishing. It's a military dictatorship intended to restrict all sorts of freedom of movement, freedom of choosing residence, freedom of expression, freedom of association, cultural rights, like national identity, from the flag to books to where to build their residence. Palestinians are constrained, and if they step against these precepts, these military rules, they end up in prison. In military prisons, sent by sometimes military courts, including children, most of the time without a charge, without trial, administrative detention. So this is the reality that the Palestinians have endured for 56 years under Israeli military occupation. So this is why I'm so intolerant these days to those who make excuses. It's very serious what happened on the 7th of October. Very, very serious, and should have been avoided by addressing Israeli impunity, because no one can expect that a people is subjected for decades to that level of inhumanity, oppression, and abuses and indignities and humiliation, and not develop hatred. This is fantasy. This is just fantasy that can be harbored in some remote rooms of policymakers in Europe or in America or in Australia. I don't know. But so this is why I spoke of a widespread and systematic arbitrary deprivation of liberty regime, which is not limited to behind bars and this is accompanied by abusive practices, mistreatment and ill treatment, and often torture, which is allowed against the Palestinians. But also it happens outside, beyond bars. Think of the physical confinement the Palestinians are subject to by the settlements built around any Palestinian village or city, the military bases, the checkpoints, the roadblocks, the segregated roads. And on top of it, there are bureaucratic layers. Palestinians have to apply for permits to the Israeli army for anything they want to do, to study inside Palestine, abroad, to take residence, to get married, to be registered, to have any... It's very heavy. And on top of it, there is another layer, which is digital surveillance, or just surveillance through CCTV cameras. Palestinians, there is literature on that, are the most surveilled people on the world. So this is welcome to the prison that Israel has built for the Palestinians in what remains of their historic land.
Yes, thank you for this answer. And what really hit me is that you how you talked about the genocide be inherent to settler colonialism in your past answer, and also in your latest report, Anatomy of a Genocide. This is quite explored, and you also conclude in the same report that there are reasonable grounds to believe that the threshold for Israel's commission of genocide in Gaza are being met. At the same time, one key finding of your report is that Israel has systematically used the concepts of international humanitarian law as a humanitarian camouflage to hide genocidal intent. So this question is twofold. What are these reasonable grounds that have led you to that conclusion? And also, how has Israel used the international humanitarian law to justify its conduct in Gaza?
Let me start by answering the second question first, because I also think that this is the most interesting argument that the report makes, in the sense that in a way, the report explores quite quickly, because it's 10,000, I mean, it's 25 pages, what has been done in terms of acts, genocidal acts and genocidal intent. But it also pays tribute to what South Africa, the South Africa legal team, has done in it as part of its legal proceedings initiated against Israel for violations of the Genocide Convention before the International Court of Justice. They have documented in much greater detail both intent, genocidal incitement, I mean, intent to an extent, and genocidal incitement and genocidal acts. But the novelty of this report, I think it's really in the way it exposes what I call humanitarian camouflage. So how Israel has justified its actions, its military conduct, its military operation in its assault / onslaught in Gaza through categories of international humanitarian law, like human shields or collateral damage, or evacuation orders, safe zones, warnings. I mean, there's been all the full jargon of IHL used by Israelis through their policy documents, through their statements, and amplified through Western media in particular. So I've never seen another genocide where the part of the, or other, let's say, for those who are not comfortable with the term genocide, but other atrocity crimes being committed by a state whose military leadership was invited over and over on a daily basis to explain how they were carrying out their operations. This is, I don't think that there is any precedent, at least in the world that call itself democratic and liberal. Because what has happened is that, in fact, Israel, by doing so, Israel has distorted, has completely capsized, has completely destroyed the full meaning, the protection meaning of the very basic tenets of international humanitarian law, like the principle of distinction between civilian objects and military objects, between a civilian and a combatant. And I will give a concrete example. It has completely erased the meaning of the principle of proportionality, because everything has become a target, a legitimate destroyable or killable target. And the principle of precautions in military action, meaning that every time before conducting an attack, there should be an assessment of the harm done to civilians. So let me tell you what has happened, in fact. Already from the beginning, and this is something I've tried to say, but there was such a vehement attack against anyone who, after the 7th of October, trying to instill some sense of logic, saying, Well, first of all, it cannot be self-defense cannot be invoked to wage a war against the entire Gaza population. But the very aim of this military operation, destroying Hamas, erading Hamas, and this is something that still it's validated in many corners of the Western world. But again, I don't dispute that Hamas has committed acts of terror and war crimes against Israeli civilians. The point is that Hamas is a political reality. It's not just a military reality. And the moment you want to erase Hamas, you set a political objective. It's not foreseen by IHL. This is beyond IHL. And what it has happened is, in fact, that Israel has been not disengaged. Has been enabled to believe that it was right to target Hamas as a whole. And who's been conceived as Hamas? Not only the combatants, the non-combatants clearly, but also civil servants, doctors, nurses, engineers, anyone was a target. And any premise was a target, because whatever connection could be drawn to Hamas, including whether someone suspected to have affiliations with Hamas had used a computer in a building. All the building, not just all the building became destroyable without looking at the military necessity, which is to deter an attack. So this is why, and every civilians who have been killed, the civilians who have been killed, now we know, including through artificial intelligence calculations, which is brutal, they've been assessed as collateral damage. And they are a price to pay, because this is what war means. Even when it's Israeli hostages waving a white flag and trying to escape, they've been killed. And aid workers, there are almost 200 aid workers who have been killed, although the world only woke up when there were 6 foreigners who, may they rest in peace, who lost their life because of Israeli bombing. So this is the reality. Israel has completely leveled the potential of international humanitarian law to protect. And if this is validated, if this is not held accountable, as of now, we will have no possibility to defend, because there is a precedent to defend ourselves from proportionate genocides, because this is what Israel has said. And then the acts that have been committed are the killing of members of the group, the infliction of bodily and mental harm to members of the group, and the creation of conditions that would make life impossible, that would lead to the destruction of life for members of the group. And again, this has been said over and over. The words of political and military leaders are not enough, but there is plenty of evidence of soldiers having absorbed, internalized, and acted upon those words. Amalek, all terrorists or accomplices, no one is innocent in Gaza, including the mothers and the children. And this is why for 6 months, 70% of the victims as of day one have been women and children. If we take all the count of children killed in the past 6 months, which is nearly 14,000, Israel has killed 85 children per day, while during the first part of this military assault, it has killed 250 people per day by using an arsenal of weapons that is shocking. That after a month and something amounted to 2 nuclear weapons. It's difficult to prove intent when it's not ostentatious and conspicuous as in this case. I know that the ICC will have to investigate and the ICJ will have to look into the merit, but I'm very confident of what I've written in that report, and I wish I had not been forced to do so.
Thank you. To stay on investigation and accountability of the potential crimes committed in Gaza, moving into the second part of our conversation, as Francesca has explained in her report and today with us, there's been a distortion of international humanitarian law, which to me, it seems like a challenge. At the same time, As with the case of the Special Rapporteur, the chief prosecutor of the International Criminal Court is denied entry into Gaza. So Terje, as an expert of international criminal law, what are, in your view, the greatest challenges for investigation and prosecution of international crimes before the International Criminal Court in this context?
Thank you. Well, I think there are many difficult challenges. Access to the territory, as you mentioned, also cooperation with Israel can be very difficult to establish concrete war crimes without also having the data from the alleged perpetrators regarding particular bombings, for instance. And then ICC is generally understaffed. It lacks resources, but it has now a team investigating possible crimes. But then there is also a political layer to this, and some fear that actually the ICC prosecutor is not that interested in real investigations and bringing cases. I have been of the opinion that this remains to be seen. I mean, some people would, of course, like to see very quick movement from the ICC, as it is also one of its tasks to prevent crimes. So maybe in some situations, an early arrest warrant could be important. On the other hand, prosecutors and police generally would like to do their investigations properly, and maybe the time aspect is not the most important for a court also like the ICC. So maybe they think that it's more important that finally the results will be correct. But then again, it is a bit peculiar, I think, that we have a chief prosecutor who is a UK lawyer by profession, and that he has appointed the two leaders of his team investigating crimes in Palestine and Israel from the UK and the US. And the US is not even a party to the Rome Statute. And also because the UK and the US has been accused of having been complicit in the crimes in Gaza. So I think this is to some people quite disturbing, and one may wonder what it may lead to. On the other hand, I mean, if there would be independent, serious investigations, which we should believe it would be, then it could maybe be a tactical advantage to have leaders of the prosecutorial team from the UK and the US. But again, this is quite up in the air for the moment.
Okay, thank you. And as you said, Western states, especially Western states like the US, UK, Germany, there is a debate around their support to Israel warfare in Gaza. Also, this week we had the first hearing of the case brought by Nicaragua against Germany. before the International Court of Justice for complicity in genocide in Gaza. Francesca, I would like to ask you in this regard, what are the obligations of third states in relation to the potential genocide in Gaza and other war crimes? And could you elaborate on the third state responsibility that could arise for failure to prevent genocide or complicity in genocide in this context?
Sure. International law is made of a series of bodies and regulating these different circumstances. So while, for example, the obligations stemming from most human rights bind states, and to an extent non-state actors, and only in a number of cases are also connected to international obligations. There are other treaties that are very explicit on international obligations according to violations that take place in one given state or attributable to one given state. For example, in international humanitarian law, the Geneva Conventions have a common article that refer to the fact that each member state has to respect and ensure respect for international humanitarian law. So this has already been violated because there were violations of international humanitarian law, including grave breaches, like a violation of Article 49 of the Geneva Convention for which prohibits the creation of colonies, basically, and it has not been enforced. So impunity has played a big role in this context. Then there is the Genocide Convention, which contains an obligation for member states, and it's a non-derogable obligation, and it's erga omnes, so applies to anyone, including those who have not ratified the Genocide Convention, to prevent and punish genocide. And there is also in the Genocide Convention an obligation, I would say, not to aid and abet. Which refers to the fact that complicity is also punishable, is prohibited. So there are a number of legal norms that refer actually to the obligation of member states, and there's also the law on state responsibility for wrongful acts. So we are in presence of a state which is committing, I would say, steadily wrongful acts. There are obligations to act to cease the violations and to take measures. The measures are established under the UN Charter, and there are countermeasures that can be of diplomatic, political, or economic nature. What does it mean? That in a context of a situation where, let my report aside, but International Court of Justice has established that there is a plausibility that genocide is being committed without even looking at the merit, just prima facie. And has recommended a number of measures that have also been not observed, violated. In that case, there is a responsibility to prevent, so to intervene, to prevent, to take measures. The UN Security Council has even finally, after 6 months, passed a resolution asking for a ceasefire, urging a ceasefire, which has not happened. So the violations, and this is primarily from Israel, because Israel has the upper hand. I mean, it cannot say no, a war is then necessary because Hamas is fighting in Gaza. Gaza is occupied territory, and it's surely not a war the way to administer law and order in the occupied territory. Although I believe and I argue that the occupation is illegal, and I look very much forward to this year's advisory opinion. of the International Court of Justice, which will add another big layer of responsibility to those who have averted their eyes from it until now. So member states at this point should consider suspending their diplomatic ties with Israel, should take political measures, including considering the suspension of Israel from political fora. I mean, there are a number of people. I was listening to an Israeli speaker who was a few days ago mentioning in the European Parliament, mentioning the need not to have Israel participating in sport events, because this has been very effective in the case of dismantling South Africa's apartheid. But there are also economic measures, sanctions. It's upon time to impose sanctions on Israel. And again, I understand how painful it is, but what else? And this is going to be in the interest of both Palestinians and Israelis, because the Israeli society, when they will realize what has been done in their name, or what many of them have taken part in, it will be a sort of a traumatic manifestation, realization for them as well. So peace cannot be restored by making war. Peace is to be brought back through respecting and enforcing respect for international law.
Thank you. As you said, one of the main obligation of third state is prosecution. And I would like to focus with you, Terje, on domestic prosecution of international crimes. You have been directly involved in the complaint that was filed with Norwegian prosecutor by International Commission of Jurists and Defend International Law against 3 Israeli leaders for complicity in crimes against humanity. Could you tell us a bit more about your case, and also what can be the role of domestic prosecution in this situation?
Okay, maybe I should start with the last one. What could be the role of domestic prosecutions? Well, under international law and also domestic criminal law, there are different bases for prosecutions regarding crimes that has been committed outside of the territory of a state. A collective term here that's often been used are extraterritorial jurisdiction or prosecution. And again, the legal basis could be different. It could relate to the nationality of the perpetrator. For instance, if a Norwegian commits a crime in another country, he might still be prosecuted in Norway. Or it could relate to the victim, who might be a national or a protected person under the domestic criminal law, which is the case regarding about 300 Palestinians who were in Gaza from October the 7th, and who we think were exposed to several crimes against humanity in Gaza, and where there is clearly a jurisdiction under Norwegian law, so-called passive nationality jurisdiction. And then in addition, you also have the universal jurisdiction, and that can have different additional conditions. For instance, in Norway, the universal jurisdiction for acts committed by foreigners abroad can only be used if the alleged perpetrator is residing in Norway, is already in Norway. So in this case, it's the passive nationality jurisdiction that has been used in our complaint, and then even if the conditions for criminal law responsibility are fulfilled, the prosecutors must also consider whether it will be in the public interest to prosecute the case in Norway. Regarding other countries, they might have more or less the same jurisdictional basis, or it could be more limited or broader in some sense. So it's very difficult to have the full overview. But usually it's considered today that about 40 countries of the world have universal jurisdictions or some versions of it. And then in addition, there might be passive nationality jurisdictions. There might also be Palestinians who were in Gaza from other countries. We know there are from other countries. And in those cases, other jurisdictions might also have the possibility to investigate and prosecute.
Thank you. Thank you so much. Briefly, last question to Francesca. One of the main role of the Special Rapporteur is to provide a recommendation to member states. Together with the sanction, as you mentioned before, and prosecution, what are the other recommendations that you provided the international community?
I've made a number of recommendations in each report, and all of them, frankly, say the same thing. First of all, the Palestinians need to, not in order, but the Palestinians need to be protected. And it's clear that the goal of the occupying army is not to protect the Palestinians, who do not have anyone, not even the Palestinian Authority, because the Palestinian Authority's work is not, or goal or mission is not to secure the life of the Palestinians in the occupied Palestinian territory, is to act in conjunction with the occupation forces and ensure the security of the occupation. This is why last year, when there were assaults after assaults after assaults, including some looking like a pogrom on Palestinian villages, the Palestinian security forces were nowhere to be seen. And this is why I say the only way to, also because Europe is so concerned with radicalization. Well, if you want to de-radicalize, make sure that people don't have to suffer the kind of oppression that the Palestinians face day by day. So a protective presence is needed, and a protective presence, frankly, is not chosen by Israel, doesn't entail control or determination. I mean, it is to be agreed upon by the Palestinians, and with the support of actors and organizations they trust, and countries they trust, and not who Israel and the United States impose on them. Enough. We are in 2024. Colonialism, if it's true that colonialism is an abomination of the past, we should oppose this kind of language where, or this kind of this political discourse where the US or even European leaders talk about the political future of Palestine without abiding by their obligation to secure the right to life of the Palestinians. So, after this, of course, I've recommended an arms embargo, an oil embargo, because this is all being used. I mean, chances are that this is being used not only to commit atrocity crimes and a genocide against the Palestinians in Gaza and the West Bank and East Jerusalem. It's creating a lot of fears, including among Israeli Jews. I mean, no one is safe. No one who stands against this genocidal violence. And there is also an increasing level of tension. Israel has been bombing other countries, and I'm surprised no one has reacted. It has launched assaults bombs in Iraq, in Syria multiple times, Lebanon. So there is the need to de-escalate the level. This is why I think that stopping to supply weapons is a good start. Then, of course, there should be investigation, and I wouldn't repeat what Terje said, which is investigating crimes where there is the ICC course, everyone is expecting. There is a little bit of dragging heels at the ICC level. Hopefully it will change. But meanwhile, national courts have a huge potential. There is also a need, in my view, to reconstitute the apartheid committee, the committee on apartheid, on the elimination of apartheid in the UN. Because again, there is a tendency to approach what happens in between the river and the sea, so in Israel and the Occupied Palestinian Territory, as a series of phenomena completely disconnected, why it's all part of the same endeavor. And if we want to help the Palestinians and the Israelis to get along, not to get along, to live in that place, enjoying rights and freedoms and in safety and security, the apartheid must be dismantled. And then I also recommended, I addressed this recommendation to the High Commissioner, to the Office of the High Commissioner for Refugees, but in fact it applies to everyone, especially each and every UN agency. There is a principle of doing no harm, and that is being violated as we speak because of so many exceptions that are conceded when it comes to Israel. And I think that on top of the political failure to prevent genocide, on top of the legal failure not to use the right terminology, and this is what I asked the High Commissioner to do, to use a full spectrum of international law norms when it comes to Israel, as he would do to any other country, because there is some reticence. But also it's important to understand that there is a need to bring an end to this oppressive system that Israel has imposed on the Palestinians in its totality. These have been my recommendations.
Thank you. We will now open. Do you want?
Well, maybe first see if there are questions. I just had one comment.
Yeah, no, go ahead.
No, I just wanted to say that this is a very challenging situation for the world, for the Western states who have basically supported Israel through the years, and also in many cases contributed with weapons and other kinds of support during the atrocities in Gaza. Which makes it, of course, difficult also for prosecutors in Western states. What should they do? Should they investigate crimes that might in next raise questions about aiding and abetting those crimes? Because as compared to more isolated instances of war crimes at a particular place at a particular time, a genocide or crimes against humanity in Gaza have been directed against the whole population. The whole population, or the civilian population, or the Palestinian as a protected group under the Genocide Convention. And this means that nearly all the acts committed by Israel in this war are part of the crime. And it also means that the scope for aiding and abetting is enormous. It's so wide that we do not know at this time how this will play out, let's say, within the next 2 decades. I mean, will there be prosecutors doing thematic investigations, cooperating in different countries, going after, for instance, companies, universities, and other entities that can be claimed to be complicit in some way or another. Maybe this is difficult to envisage right today, but who knows?
Thank you so much for this. Now we open the floor for questions and ask you to make them as question, not statement, and very brief. We will collect 3 questions. We have a question there.
Thank you very much, Bjarte Bjørsvik, International Committee of the Green Party, Norway. There are many topics and many actors involved. and I have a question regarding the legal aspect. Norway, the pension fund, so-called oil fund of Norway, is the biggest investor with about 13 billion US dollars or 140 billion Norwegian crowns, according to a recent report from Fri Fagbevegelse, the union in Norway, in companies that are involved in settlements, which are under illegal occupation. So my question is, can you give a legal opinion about these kind of investments? It's basically banks, but also some big companies.
Is there other questions?
In the back. Oh, sorry.
Yeah.
I can pass it. Oh, it's me? Okay.
Yeah.
Oh my gosh. I have my question in Norwegian in my head, but I'm just gonna translate quickly. So recently, Iranian officials were attacked and killed in Syria and Damascus, and Iran has proposed a ceasefire instead of retaliating against Israel. They've proposed this to the US administration, the Biden administration. But if I read correctly, the Biden administration has denied this proposal. Like, they haven't said that it's true, but there's no news coverage on this. So I'm wondering, do you have any insight on what is going on in terms of that?
Thank you. And then,
if there is any further people. Thank you for the insightful inputs. My question is that now we see that there is a focus on self-determination, either by Palestinians and also Israel, but specifically the former. So my question is, what is next? Is it possible to consider the intervention of peacekeeping of UN to guarantee the protection of civilians, especially considering the Israeli settlers in Palestinian territories? And also, what are the implications of this? Can for example, the peacekeeping efforts in the future, let's consider that the futures of establishing a Palestinian state can bring in the table, considering. Thank you.
Francesca, you can provide the answer to this question.
Shall I start?
Yes, thank you.
Look, I will let Terje comment on the specifics of the pension fund, because this is something I really wanted. I mean, I learned when I was in Norway last year, and I was so shocked to see that Norway had such a huge investment in the settlements, including through pension funds. I was asking, but do people know? Do Norwegians know that the money they put aside, trying to secure their future, might be used or to destroy someone's present, including children? And of course, there is not that much of transparency, and there's chances are that people don't know, in fact. So it was my interest to, I even had a call for submission to investigate and document this kind of behavior, responsibilities of financial and business corporations. And this is not something I've looked at because of the genocide, and I will. But the thing is that there is a member state, if we have to be really honest, there has been so much hypocrisy, especially in Western states, not only, but especially, because there has been a rhetorical support for the Palestinian rights. But in fact, what has been done in general, apart from few exceptions, and even that was not enough, has been little, because what had to be done was considering measures to, first of all, no one can make investments in an illegal endeavor without facing consequences. So there is the question of state responsibility, which I mentioned before, due diligence from the business and financial corporations themselves. So there should have been legal consequences, and I hope that there will be such a legal scrutiny at the domestic level through lawyers' organizations and through civil society, because it's about time. Now I hear that Ireland has announced its divestment from the divestment of its pension funds from settlements, which is good, and I think that this is a path that Norway needs to follow. I mean, I'm even shocked that it's not been done yet. Sorry, I cannot comment on the second question because I don't know enough. But again, it would be very interesting if it was confirmed true that Iran, instead of going ahead with the usual hubris that we see states using, so I get a threat and I reply with military violence. This is a word in which diplomacy has been completely thrown out of the window. So it would be, I'm interested in following up. On the third question, which was formulated in an interesting way, because you said now that there is attention on self-determination, I don't think there is attention enough. Policymakers still don't want to understand what self-determination means. It means freedom to exist and freedom to defend themselves from the possibility of being erased, and being protected from the possibility of being erased. So peacekeepers, as I said, I think that peacekeepers are necessary, but for a limited time. It shouldn't become the new status quo for the Palestinians in perpetuity, and subject to 6 months, 1 year demilitarization, Israel's demilitarization of the occupied Palestinian territory. I'm not calling for an eradication of all the settlements, but surely the land that has been privately expropriated to private owners, needs to be returned in whatever forms. The public, what was public property, well, there will be negotiation and possibly compensation. But again, I'm just suggesting what has worked in other contexts, and this doesn't replace eventually Palestinians' sovereignty. Now, when it comes to make decisions in this regard, and I think that it's about time not to interfere anymore with Palestinian decision-making process. So they will need to have an elections first and foremost in the occupied territory. But thinking of the future, I'm not sure that a two-state solution is what the people on the ground want. This is something they will have to express themselves, both Palestinians and Israelis.
Thank you. Terje, do you want to add something in relation to the questions?
Maybe just only that there is this other case before the ICJ. It's an advisory opinion to be delivered maybe later this year. And it concerns the legal consequences of the illegal occupations of Palestine. And I think it's quite reasonable to expect that the court will declare the occupations of East Jerusalem, Gaza, and the West Bank as illegal occupations. And I think they will then also follow their earlier precedents. For instance, in the Chiara case against the UK, that this means that Israel must immediately and unconditionally retreat from the occupied territories, which they will not do, of course. But it will then be clarified that they are under such a illegal obligation. And I expect that the court will also discuss what are the implications for third states. and this can be important. So in fact, Western states might be presented with a choice of breaking in clear daylight international law, or to adhere to it.
Thank you so much. Thank you so much, Francesca, for joining us, for your important contribution. It was an honor, and thank you for Terje also and to everyone that came today. Tomorrow there is going to be an event on elections, the upcoming election in South Africa, here at 8:30. And remember to check out for a more exciting event the website of Bergen Global and Law Transform. Thank you so much to all for being here.
Thank you. Thank you for having me. Bye.
Yeah.